of July, documents which are lying in the system somewhere, not in the system, in the email addresses of the respective courts. And then we have now the documents which are lodged into the e-filing system, which I can confidently say they are not lost. They're actually in the e-filing system. So what we are doing is that we are giving our users respective email addresses so that we can have before we say that the documents are lost, what the documents that were in the emails, we have uploaded them into the system. But if, for instance, you go to a magistrate and the magistrate tells you that we cannot trace your email, especially at the Chief Magistrate's Court, because at some point that email address was closed and we couldn't get access to it. So they have created a specific customer care desk where those documents are being sent to, and then those documents are being uploaded into the system. So we are very live to that challenge, and it is being addressed in the respective courts. But there is also a process of scanning which is happening now, so that we scan the documents which were physically filed before the system was rolled out, and then upload them into the system, so that you have one complete e-file. And for those existing cases which have already proceeded and have gone, we are almost at the end of it. Once you file your document in the e-filing system, we print it out and put it in the manual file, so that a judicial officer can have either one manual file or a complete e-file. But I'm aware of the transition period where some documents are in the system, some documents are in the manual files, some documents are actually lying in the email addresses. So we are addressing those challenges.
Okay. So there's been a challenge of lost files in the previous way of dealing. Is this something that will now be a thing of the past, or we will still continue dealing with mysteriously lost files in the registries for whatever reason? One, and then two, this is actually from a personal experience. Sometime last week or early this week, a matter is listed in a different court, but then the file is taken to a different judge. It felt like monkey business, but we were asked to go and address the issue with the DR. And I haven't written that letter because I was still pretty upset. I'm waiting to calm down so that I can address it in the most appropriate manner.
Yeah.
So these issues of lost files and all that, how is it going to be dealt with? And then how has this transition been for you, the stakeholders on the judiciary side? Because, you know, I understand that we can be very pushy, myself included, but, you know, I would like to hear how it has been on your end and how you're managing. And also, there are people whose numbers were given to reach out to them when we're having challenges, but they pick or don't pick, but when they pick and they realize, or rather they listen to your query, but then when you call, you never reach them again. So those are challenges we're experiencing. How are these being mitigated, and have you made any plans to give us a smooth experience moving forward?
Okay, let me start with the missing files. I think why we need to celebrate this initiative of the e-filing system and really embrace it is because now we will completely do away with lost files. Lost files or misplaced files come because we have numerous paper that we are dealing with, and you have come to our registry sometimes and you find files all over the floor, files on the shelves, because we have been building paper all over. But with the e-filing system, it is paperless. So the documents that you have loaded into the e-filing system will be in the system. We have backup servers and a very good database, so we will not lose any document that has been filed into the system. And as I said, we are in the process of scanning historical documents and ensure that they have been uploaded into the system. So I think one of the things that we need to celebrate is the fact that we will now be beyond, you know, missing files. We will be beyond misfiled files. We will be beyond the fact that a file has not been taken to the court, because a judicial officer just needs to log into the system. So long as you have the case number, you search for that case, and there you are. The documents are all there. And even for you, from the comfort of your office, you can be there to look through the file, because you are accessible to that file, just to ensure that that affidavit of service that I filed last week, is it in the system? you know, because you have the interface that we have in the registry is the interface that you have as a user. There is no other, that file is the file that the judicial officer will look at. It is the file that you're looking at. It is the file that your client would possibly look at. The other question that you asked is about the issue of listing. You list a case in a different court. I think that has come about because of the virtual registries. I mean the virtual courts that we are having now. But I think that could be a very isolated case. You know why I'm saying it's an isolated case? Because our cause lists are generated from the system. You have been able to log into the system and you have seen that the system has its own calendar. So that if you have your case, for instance, listed next week, you can actually confirm the same in the system when you go to the activities tab. Now, the cause list for every judicial officer is not done manually, but it is generated from the system. So it is very, that's why I'm saying it's an isolated case. It's very difficult to have a mix-up where one case is listed before another judicial officer. The fourth issue that you raised is about how we are handling it as internal users of the system. And of course, the pushy advocates and the fact that you can call me at 9 o'clock at night because, you know, all our numbers are outside there. I think after the pandemic, and we really wanted to give people access to justice, we went beyond what is required and ensured that you have the contacts for every deputy registrar in every registry. We have even gone ahead and given the contacts of the court assistants to every judicial officer. And that came about because people were complaining that they cannot get the links to the various courts and they cannot therefore access the courts. So the court assistant, then you would call the court assistant and the court assistant would give you the link. But we have gone beyond that and we have said that every court will have a permanent link, and that permanent link is now in the cause list. It runs with the cause list. You can access it at the Kenya Law Report so that you don't have to call me to ask me, can I get a link to for instance, Justice Kasango's court. It is there and it is a permanent link. So we have gone through tough times as internal, as a judiciary staff, stakeholders, the inside stakeholders. We have had to, you know, address the issue of answering email addresses as late as at night, and especially between March and 1st of July before the e-filing system was rolled out. Because you see, all the documents that come to court were being filed through the email. And I could therefore be at my email, at my desktop until very late at night because I want to assess your documents for you. You're coming before a judge the next day. I haven't reached, and it would be an email after an email, and every email has an attachment. This attachment has to be assessed. I have to tell you, you pay 75, you pay 10 shillings, you pay 3,000 shillings, you go to the bank. The next email, this is, you know, an originating motion. The next email, this is a notice of motion. You know, different documents with different amounts. It was a very challenging period for us. But came the e-filing, and we are so excited in the registries ourselves, because all that work that we used to do late at night and very early in the morning is being done through the system. The system is assessing the documents for you. The system is prompting you to go and pay the bank. I don't have to write an email to you. The system is, you can see the status of your case. We have had challenges about people not receiving calls, and I tell you, it's been a difficult period for some of our staff. So you answer as many calls and as late as I said at night. So you know, it's human nature that you would not want to pick a call sometimes. And at that time, you have a certificate of urgency and you have sent an email. Nobody has acknowledged your email. So we would understand the frustrations from out there. But what we are doing now is establishing a call center for the e-filing platform. In that call center, we would have it equipped, have personnel who can answer your questions, and they will be working on rotational basis, so that we have personnel who are working between 1 and 2, and we have other personnel who are taking over from 2 to as late as 6 or 9, because it is a 24-hour e-filing system. You can file your document at night. But you see, if you have not been mapped to that system, as late as 6 and you have to file a certificate of urgency, there is no way you will file a document, an additional document. So you need somebody to call as late as 9. So we are in the process of just having that unit who can work even at night. If you want to file a document, they map that case to you, and then you can file your document. So we are, as I said, it is 3 months, 90 days into the journey. We are looking forward to an ideal system where you can file your document as late as 3, and you can call and somebody picks.
Thank you so much. Well, being one of the people who've interacted with this system from when it first came on board, I actually acknowledge that there's a lot of improvements that are coming on board. And just to urge you and your colleagues to bear with us when it becomes unbearable. It's just because even as we have a lot of pressure from our clients.
I can imagine, we
but
understand.
Personally, I'm very happy with the e-filing system because it makes things very convenient. And also being a mother, I am happy to be working from home, so I can conduct my hearings from my home office.
Happy to know.
So keep up the good work.
Thank
and
you.
Now I will hand over to my colleague, Ms. Kinyili, so she can address any issues she may have. Thanks.
Yes, my query before, as we have this conversation before we began, can I as a client, let's say it's a client, or can you access the system as a client? Or what happens in the case there's a notice of change of advocates?
Okay, so you can have, the system has been designed in a way that you can only view a case if that case has been linked to that account. So you can open an account as a party, a self-representing individual, a self-representing organization, or you can use an advocate firm. So for you to then access that file, your account, that case has to be mapped to your account. And I have had that discussion with you prior to this discussion. And I've just been thinking about it. Right now, the way the system is designed is that if you have, for instance, an advocate, that advocate has an account, that case is only mapped to that account. But what would happen before the e-filing system? Clients would come to our registries if they do not want to go to their advocate. For instance, if you have issues with your advocate, or if you're doubting what your advocate is doing, and you just want to know, can I just have access to this file and see whether my advocate has filed a document? So you would come, and you would pay, and you would peruse the file. So long as you make a request and you justify why you want to peruse that file. So for now, the system has not been designed to allow clients to directly access that file if that file has not been mapped to their account. But if you can justify that, not even justify, just the way the manual system had been done, if we get a call, for instance, from a client, and that client just wants to peruse that file, the first question I would ask is, do you have an account as an individual? So you might have an account as an individual, and then the other question is, why wouldn't you then want to go through your lawyer? Because you see, if you have to access that, that file, I would ask you to talk to your lawyer. So you might want to tell me that my lawyer and I have differences. We are going through a not very good relationship. So you would want to just confirm. So for that particular period, if you just want to access, I would map it for you manually so that you can have access to that file. But it also raises other issues, and I'm sure the advocates who are here might want to have further discussions on that. But we have been allowing you to come to the registry. We have been allowing you to access the file so long as you pay a fee of 150, which is a perusal fee. So we can still allow that to some extent, but just for you to peruse, and then thereafter we delink you from that account. But the other way and the easier way is ask your advocate to give you the credentials to the account, his account, and then once you have the credentials to that account, you can view your file. I don't know whether I've convinced you. Yeah.
Yes, you have. And it's something that has just come to me, just in the event, let's say, of death, as I said, or change of advocate.
Yes.
What happens?
Yeah, for change of advocate, actually we are mapping the advocate who intends to come to the file directly for now.
No.
Yes, because we would, and I said our processes and the procedures, the logic that has been built into the system is a mirror of what was happening manually. So manually you would come to the registry with a notice of change, and you would just file it. So the same way, if you can initiate, because you see you have not been mapped to that file. I mean that file has not been mapped to your account, so we will just do it. We will have that account, we will have that case linked to your account, and you can then file your notice of change as an additional document.
Okay, thank you very much. I think you've answered my query. Our next panelist is Collins Wanyonyi. Collins Wanyonyi is a seasoned banker with an experience spanning 20 years across most banking segments, including banking operations, corporate banking, commercial banking, SME banking, and public sector banking, with the last 3 segments at head of business unit level at both local and international banks. With a Master of Business Management degree from the University of Nairobi and a Bachelor of Commerce degree from Day5 University, he has also achieved accountancy certification by CASNEP to Part 2 level. He has just enrolled for a PhD in entrepreneurship. As a sportsman, he has actively participated in hockey, soccer, and rugby, right from secondary school to campus level, earning his Sports of the Year 2000 at Day5 University. He played for Wazalendo Hockey Club, a hockey Premier League club in Kenya. In his quest to make the world a better place, Collins has served the community in various capacities, including chairman, Valley View Residents Association for 5 years, with a 1-year stint as vice chairman before that. Chairman, Stanbic Welfare Committee for 3 years, the current treasurer for ASDIC, an NGO for the last 8 years, and serving in the Devolution and Planning Subcommittee of KEPSA, seconded by Stanbic Bank. He was recently appointed as a board member for RCEA Namunyiri Girls School in Tongaren, Bungoma. Outside his official circles and aside from his family engagements, his other passion is farming and outdoor sports, with growing interest in entrepreneurial capacity building. Karibu Collins to this panel today.
Thank you. So when we talk about justice, most people then look at justice from legal, going to a courtroom and then ask yourself, there's a complainant in a courtroom. But then we want to look at justice from a banking side, and we want to look at the trend and the change of things, how the current customer operates. So we are coming from a situation where we had banking structures that required you as a customer to walk to the bank physically, to walk to the bank to then demand for service from there. And we've seen changes in the scenarios where right now, if I look at Stanbic Bank, you can open an account remotely. You don't have to come physically to the bank. You can then transact. So you can technically run a bank account without ever stepping in a Stanbic Bank branch. But then the question will be, and we now look at justice side of it, is if you have concerns, if you want to be sure that the service you're getting is value for money. So how does it come in? So a few things that the bank has done is, first of all, any service that you get from the bank, all the terms and conditions, we have reviewed them as TCCs, are available, and you can verify the documentation before you accept, and all those documents that are accepted are saved somewhere. So it's actually something that, if need be, they can be printed and available to you. And for customer complaints and follow-ups, if a client has a concern that needs to be addressed, we've embedded social media into our customer response platforms. So you can raise your complaint via Twitter, you can raise it via Facebook, you can raise it via Instagram, and we should be able to get back to you, and we have clear timelines and how much time it will take for you to get feedback. And it has escalations. So if you need a complaint that was not addressed within the 2 hours that we promised, it escalates to somebody else who can be able to review that. And for each case that you raise on any of these platforms has a reference code. So you actually, with that reference code, you can pick up and say, my case number XYZ, number this of this date that I lodged on this day at this time has not been addressed. And if need, then you want to go the old way of making a call and visit a physical branch, then you have a document, you have a piece of information and a reference number that you can be able to pick to address this. So for us, it's in a way that we are trying to make it easier for our clients to raise their concerns, to raise the expectations about the service. And we've seen how Kenyans in general have used social media to raise their concerns in public and build up on that. So we've taken advantage of that and then say, how do we tag this to provide, I'll call it justice to our customers who have concerns about our products and services.
Okay. For me, my query would be on integrity of the mobile banking system. I think that is an issue which there have been complaints on quite a bit, where some details or somebody gets into your account, or somehow somebody calls you, asks for your details. So basically, I think for the common person, how sure am I that my money is secure and we won't have some hacker somewhere getting into my system and having access to my money?
Thanks for that. I think the government has really enhanced its security system. So one of the things that has helped us as a bank to be able to have, for example, as I said earlier, you open an account remotely, you do your transactions remotely, is because with your ID number, there's a direct linkage to the government's IPRS system. So you can actually be able to verify that the person who's giving us this information is genuinely the person behind the phone or on the tablet that is opening this account. And then any further transactions are also verified against that. You'll realize one aspect of the people who call you to ask for details. So they will call you and tell you, dial XYZ, and then we'll give you this information. So you technically choose to give them access to your system by keying in some codes that they have given you. So my advice has always been, if you don't trust the person on the other end, please don't even share your first name.
As I said, that may be true for some of us, but what about that grandmother in the village who believes by the time who would have gotten, because my details in the first place, would have known that I have a number, and number two, that I have an account with that particular bank?
Quite interesting, and I take comfort from my grandmother. She's still alive, 105 years old. She never went to school, but when you send her 1,000 shillings, she will call you and tell you, yes, I've received 1,000 shillings in my M-Pesa. So I'll take comfort from my grandmother's bit. So when there are basics, when we engage our customers, we share with them, and we've seen Safaricom, for example, come with media campaigns around it and say, your PIN is your secret. So vulnerability exists, and we all know Kenyans have been quite susceptible to fraud. We've seen the pyramid schemes, and the people who have been defrauded from the pyramid schemes are not your usual, what we call mamamboga, professors from universities. So I think it's just about how clear are you to the people you're interacting with and the person you're giving the information. So if I'll switch back to my grandmother, I'll say I'm probably one of her trusted grandchildren. So when you give her information, she will call me and tell me, so-and-so called me and told me this. Do you think this is right? So all these people that we engage with, they always have a trusted person that they can turn to. And my advice to anybody who's using technology is, if you don't trust, if you don't trust what you're seeing, don't touch any other screen. You're better off, for example, if somebody's calling you on your phone and you feel like the discussion you're having on your phone, the conversation is not going to a way that you like, the safest thing is switch off your phone. You'll have disconnected all the connectivities that you had. If this person has to link up with you, has to start afresh, and chances are you are more highlighted. So I think the there's somebody out there whose main occupation is to see how vulnerable Kenyans can fall into their traps. And the comfort I'll then give is, if I look at what Stanbic has done, is we have three levels of authentication whenever you are accessing your platform. So one, we operate this from a HTTPS platform, so there's a security level for you to access. It's not just on a HTTP, but on HTTPS. So what it means is if you log in and the link you're using has no security feature on it, you will not access. There will not be further access. Then the second level is you put your normal password, what you've created, and our normal passwords are reviewed every 14 days. You have to go through the mechanical process of changing your password every 14 days. And lastly, every transaction that you run, there's a one-time password that comes. So even after you've logged into your transaction with your normal passwords and all this, each transaction you run will give you a one-time password just specifically for that transaction. The three levels of security then ensures that you who is transacting on that facility is the real person behind the transaction and not some imposter who's taken up your access.
Okay. Thank you for that clarification. Now my query would be, what's the future in mobile banking? Soon will we have to close branches and just operate from behind our tablets and our smart gadgets?
Especially for, I'll start with individual bank customers. I think, as I said earlier, for an individual Stanbic bank customer, you can actually open a bank account and transact without ever visiting a branch. And thank God for what the government of Kenya has done with the systems, to the extent that you can be able to verify an IDs, whether an ID is genuine. You can do all these things remotely. Secondly, with the registration process with the registrar of companies, we've seen you can be able to register a company without physically visiting the registrar of companies. We can also then verify the authenticity of the documents you're supplying to us for purposes of account opening, and do all that within a span of an hour, and you have a bank account. So yes, I think looking at how technology is being absorbed and how the security features are being rolled through the technology, we are coming to a time when people will not visit their bank accounts to do banking. Currently, I say I work for the bank. For this year, I don't think I've transacted from the bank, from the branch, I think probably for the last 1 year, in as much as I pass one every day. And I don't think I have worked with my debit card or anything in the last one. Actually, my debit card expired 2 years ago and I've not renewed it. So technically that tells you I've not been to the branch to even collect the card that was there. So the way life is moving currently, banking is moving more branchless, and that's one of the things that Stanbic Bank has absorbed, to then say how much more can we do from branchless, paperless. And we've also seen further, for example, debit cards and credit cards have gone through some risks engagement, and Stanbic and two other banks have now moved to a cardless engagement. Because previously you needed to, we've seen people picking up your card and abusing your card to the extent of getting into some fraud. And we are now moving to a level where you can transact with your card without passing your card to somebody else to touch, because you don't know what that person is doing behind the counter with your card as you're standing there to make your payments. So we are coming to, can I say, a touch and go kind of engagement with your card, so that nobody else is handling your credit card or a debit card when you're making a payment. And all this is towards enhancing levels of security to you, the end user of the cards.
Okay. Thank you very much. I think I will cede over to my co-moderator, Ms. Ingati.
Collins, for me, I'd just like to understand how your bank is supporting SMEs, and mainly with regards to the data product, because I have been seeing it around a lot, and by virtue of the word data, I would assume it is a product that supports women in business like myself. So I'm asking this question on my behalf and on behalf of women in business in the legal profession, what kind of support can we get from your bank, and to push us to the next level in terms of a reliable financial partner? And do you have any business-related trainings, conversations for subscribers to this product and etc.? Thank you.
Thanks. So I'll start with data, and why data? It's because we're quite passionate about it. So data is an abbreviation for dare to aspire, dare to achieve, and we're mostly focusing this on the women folk. Historically, for those who are slightly older than me, will remember that as a woman, at some point, you wouldn't have registered a business. Even if you look at business certificates some years back, it was either Leah Ogada, wife of Collins, or Leah Ogada, daughter of. So you wouldn't have just registered a company on your own as a woman. We've also seen women suffer the African culture where a woman is not meant to own land or inherit land. And so as Stanbic, we've then come in to say, how do we ensure that women then get services from the bank across all aspects of the bank, to the extent that they are not indiscriminated upon by just virtue of being a woman. So you don't walk in and say, because you are a woman, you won't be able to get this kind of service, of that kind of property engagement, because we know in this country, if you don't have a title deed, the traditional mind has been, without a title deed, you won't get a loan. So we are trying to demystify how then service to the women is extended. We have run various partnerships with a number of institutions. We've run partnerships with IFC, we've run partnerships with Microsoft, we've run partnerships with Google, and all these training and engagements have been to help build capacity of women entrepreneurs and individuals as women, just to see how much more they can be able to achieve from where they sit. So if I'll give an example, first of all, for the corporate business, what do we determine as a business being led by a dada? It means the shareholding is at least 50% plus one. Probably we're not talking about elective politics in Kenya. But so it has to be a majority women-owned or a majority women-run. We've relaxed some bit of expectation of what we get, what you get in terms of banking requirements. So it makes it easier for you to access most of our services. Somebody would say probably the boy child has been neglected here, because what we are not doing for the boy child as we do all these efforts to the dadas. But it's because it's been a man's society. Reality, we have to admit, it's been a man's society. So you're not just making it a better thing for the women, but also making it easier for them to do business. Then I'll switch gears quickly to SME. We call it enterprise banking. So the typical challenge that an SME has faced, and I look at it from a Kenyan perspective, is twofold. The first one is access to financial services. And the access has been limited on the basis that, one, it's their level of decision making, two is their levels of documentation, and three is their ability to run research around what they need to do. And we've all seen the scenarios where if today I start a chips shop by the roadside, I'll be the first one. Within a span of 2-3 months, there'll be about 3 of us all selling chips at the same spot. And you ask yourself, okay, so why are all these people going to sell chips at that point? It's because they've just seen the number of people walking to the next person. So one of the things we're then coming in to say is, as we engage SMEs, before we even discuss about giving you money, how much information can we share with you around planning your business, around strategizing for your business, around marketing for your business? We've seen a change in trend where people are no longer putting up billboards. People are going to Facebook, people are going to Twitter to socialize on their aspects. We just had a discussion with Google where we were helping our SMEs to set up their websites and run their businesses. So those are the levels of engagement that the bank is doing to support the SMEs. But the critical end game is, as Stanbic Bank, when you're engaging SMEs, we've moved from discussions around what security are you giving us to give you loans, but you're looking at what is the kind of business volume you are running, and to that extent, how much money can we advance to you on the basis of the business activity and not on the basis of the title deed that you hold?
Thank you. I don't know, Dinda, do you have any more questions for him?
Thank you very much for your very insightful presentation.
A bit of housekeeping for those who are following these proceedings virtually. You can text your questions on the chat section, and then we'll address them at the end of this panel so that we can have our panelists address them and answer any of the queries you may have. Thank you. So I'll invite our next speaker, Ms. Linda Bonyo. She's the CEO of a Lawyers Hub, and she's a person that makes me very happy because of her journey, and I look up to her. So she's a founder of the Lawyers Hub, which is a Pan-African community of lawyers working to employ technology to ease access to justice for tech startups, improve digital skills for lawyers, and offer policy alternatives within the tech policy arena to African governments. In 2017, Linda founded the Lawyers Innovation Hub in Nairobi, the first legal tech hub in Africa, to support tech startups and cross-disciplinary collaboration in law and technology. The Lawyers Hub has grown to convene the inaugural Africa Law Tech Festival, comprised of a Law Tech Academy, Africa Legal Hackathon, Africa Digital Rights Concert, and Africa Policy Co-Creation Conference, bringing together 20 plus African countries and over 1,000 unique attendees in 2020 alone. The Lawyers Hub has recently launched the Africa Law Tech Association, with Mozilla Foundation as a founding member, to amplify African voices within the continent. Linda is an advocate of the High Court of Kenya and serves in the ICT committees of regional bar associations, such as the Pan-Africa Lawyers Union and the East Africa Law Society. She's a firm believer in the power of legal innovation as a catalyst for socio-economic growth. Linda, karibu sana, and I would like you to school us, because I don't know what better term to use based on this bio that I've just read. It's a bit intimidating if you ask me, but what role does the Lawyers Hub play in the policy development policy development areas around the law and technology developments in Kenya, in Africa, and in the world? Karibu.
Asante sana. I was wondering where you got that bio from, and then it hit me. But thank you very much. The Lawyers Hub is trying to fill the gap between law and technology. And so we are trying to work on two things. In relation to the Legal Awareness Week, we're working on justice innovation to see how do we innovate issues on justice. We accepted, I think, a few years ago that the lawyers weren't really good in technology, and that has shown in how we conduct business, how we conduct our, our clients' business, as well as what we know within the tech policy space. So we do two things on justice innovation. We support legal tech startups, people that are building products that would improve access to justice. We also have been focusing on startups. We realize that tech startups are building incredible things, but they do not actually have, the lawyers that understand the issues, their problems, issues coming around intellectual property. Some of them are building stuff on artificial intelligence that is pretty new and is affecting issues like copyright, for example. And so we are trying to offer that particular help. We are now working in Kenya, Nigeria, Uganda, and Rwanda, and Tanzania as well. And so what we do is, on the legal side, is to look at how do we conduct trainings for lawyers to, get to understand emerging technologies. We've run trainings before on artificial intelligence and the law, blockchain and how it's affecting the law and the law of evidence as well. And we're also looking at tech policy issues in that particular regard. And I'd want to just maybe shout out, we are also accredited by the Law Society to offer CPDs, and we're beginning to offer CPDs, next week. So if you haven't gotten your point and are interested in technology, you could look out for the CPDs that we're going to be having, between now and the month of November. I hope I answered your question and did not advertise.
You did, but because you see, right now we are moving. No, let's not say we are moving. We are now firmly in the use of technology to access justice and basically run our day-to-day activities in terms of transactions, in terms of doing business. So I just would like, because I know for a fact that you were once on this side of the world in terms of practice, and then one day you just closed shop and started the Lawyers Hub. And I'm also aware that there was a lot of banter around what you were doing. So not many people understand what the Lawyers Hub is all about. And that's why because you know the practice of law is not just about going to court or in-house practice like my colleague Linda here. There is also the policy aspect of it, which is why I'm a bit focused in that respect, because I know that's what you do from a large perspective.
Okay. So I think I'd get into the policy side of things by responding to the presentations I've had, especially for the DPP and ODPP, as well as the judiciary and e-filing. We've had the privilege before to work with the ODPP in developing their strategic plan, and we had a policy hackathon. I'm really impressed by the progress on getting this online, and I think the system has been built in such a short time as well. And the judiciary, I believe that this has been a really good progress for us. And we are allied to Africa. Nigeria spent most of the COVID season fighting having a court case on why virtual hearings are unconstitutional, which is really funny when we'll think about it maybe 20 years to come, because somebody will be, a young child will be like, I went to school on Zoom, like why wouldn't I come to court on Zoom or Teams or whatever it is, but I think Kenya is way ahead, and I think as lawyers during this pandemic we failed the public, especially in access to justice. We spent a lot of time, fighting and saying, open up the courts, and we didn't think through what were the alternatives, what was the alternative, what are the major issues. So I think the three things that we should have done better. One, we should have focused on the discussion around e-filing, for instance. We should have focused on procurement and looked at who's providing our technology, for example. Is it open access, in that particular case? Is there a vendor lock-in? If Microsoft is providing the technology that we're using to hear cases, then what happens when Microsoft is leaving? What happens to our data? Is this data on local computers, on these servers, where the servers based, are they based locally? I think those are the questions that we should have asked as members of the Law Society at that particular point, because these problems are coming. We don't know the deal. For example, we don't know the contract between the judiciary and who's providing their platforms. We need to know, because eventually we may be taken for a ride, and the lawyers didn't understand these particular issues. The concept of vendor lock-ins is really, gaining traction across the world, that governments need to have technology platforms that are interoperable, that you could actually, if we say we are leaving, Microsoft today to join Zoom, then we are fine. We don't have to lose our data. We don't have to have it in a format that is not machine readable in that particular sense. So I think we should have done better in that particular regard. Number two, we should have looked at issues on data governance that have pointed out a little bit on this, like how is our data being handled, especially in cases that are very sensitive, in this particular case, whose hands is it on, how is it backed up, and issues like that. And I think three, we should also have focused on open access, that can our media access hearings and, mentions online, on what particular platform. Also the court users in this case, if somebody is a litigant, can they access, hearings and virtual platforms? The judiciary has mentioned, and the registrars mentioned the issue on only people who actually have a lawyer have a better chance of using the platform. We need to think through, Article 19 of the Constitution on just removing technicalities and also improving access to justice, and even Article 10 on public participation. How do we ensure that the public actually have access, that these court users have direct access, and they don't have to go through lawyers, because some people don't actually just want to keep lawyers in this particular case. I'm interested on how Okiya Mtata is accessing the platform. I hope that maybe that could be, a good case study in that sense. So I think on policy, what do we do next? Now that we have, we are on a particular tangent on getting to, the digital age. I read something that really inspired me. Someone said that the COVID was an accelerator, and that the world jumped 10 years ahead. And so they keep saying that whatever was Vision 2030 actually has become Vision 2020. The things we were hoping for on access, on water, on online learning and things like that have actually become real in 2020. And so even in our learning, we need to leapfrog 10 years ahead in getting there. So what do we do next? I think we need to focus on interoperability and seeing how does, for example, Wakili Mkononi was building some really good stuff around access to justice. We've had Patafile, for example, that has been working on, on having case management for law firms. How do they, and various other, platforms that have been building, lawyers who are building really good technologies. How do they integrate with what Wadilifu is doing for the ODPP as well as what e-filing for the judiciary is doing? I think that interoperability would help us to move forward. We need to look at APIs that would help us to interlink all these things that are doing. For instance, if you read up on Estonia, for example, as a country, they have e-governance that is all interoperated, that you only go on one platform, you don't get access to all the data, but it's a gateway in which you get, data on different sort of ways in that sense. So I think we need to think through interoperability and stop working in silos, and look at even how do you integrate the LSK platform and membership to what's already happening with the judiciary. And that means that you could use the LSK platform to actually, verify that this is actually an advocate that is now accessing this platform. If it was a member of the public, that they could actually have access to Wadilifu through eCitizen, and you know that already eCitizen has verified who they are, because digital identity is now a huge thing, and you proving that who you are through, they say, digital trust, will be useful for us in that particular sense. So I think interoperability is a good thing to do. I also think, too, we need to look at, legal informatics and what we can do with data. It will be important for budgeting. I see almost every year you have judiciary saying we didn't get enough money, for this and that, but we don't have a lot of data. We don't even know how law firms operate. We don't know how many law firms closed in this pandemic. We don't know how many people accessed justice in the last 3 months. I think the data we have now is actually by the Hague Institute for Innovation in Law, HIL, from 2017, about justice needs. That means we need to really focus a little bit more on being data-centric and looking at how we could use data to allocate resources and also to look at priority areas in that particular sense. I think 3, we also need to now get into the policy questions around infrastructure. That how do we get people to access internet? When we were starting before, the lawyers have people who are asking, "Sa mnafanya nini?" And we're saying we want to get internet to you. The way data is costed means there are taxes on it. There's a tax that is paid. We have the universal service tax that is managed. Is it well managed? Does it ensure that people in the remote parts of Kenya can actually have internet and they have, good, meaningful connectivity that can help them to access court processes, for example? Can we look at having public places, the way we used to have cyber cafes and Simu ya Jamii? Can we think through, what's what now they call public digital goods? Can we have public digital goods that people can use to access court services, for example? That I will go to a place in a town hall and it has Wi-Fi, and there are booths that we can actually get internet and access court processes. I think that we need to do at policy level and look at how to allocate resources in that particular sense. And now the judiciary now, of course, you've seen what it means to get, into a place where everybody has to go online. The Chief Justice has been launching court buildings and premises that are, they're big and, everything. But the major question is, can you do a video conference? Can your witnesses join you from across? Do we have stable internet? I think we need to look at public digital goods in that particular sense. And then I think finally, we should remove, second last, we need to remove the human element in everything that we're doing. The human element is really corrupt. We're digitizing lands registry and it still depends on a particular clerk, who's gonna click something. Even on eCitizen, sometimes it still depends on somebody at Sharia House that that will fast track something. I think removing the human element will help us to go in a long way. Even for what has been said around customer care, how do we remove the human element and ensure that a lot of these things are automated, because the generation we now have, like millennials don't like to speak to people. If you call somebody, even my colleagues at work, we fear phone calls. If you, please text, if you want to talk to me, text me fast and then tell me, heads up, I'm going to talk to you in 10 minutes. So that's a generation we are raising that may not want to talk. They want to chat with bots, online and get their matter solved. How do we solve that and remove that, human element? For those who want to speak, I think that's still okay. Finally, I think we need to understand that our client has evolved. They've become more sophisticated, and therefore, even their needs, their justice needs are different. From what Stanbic Bank has mentioned here, we are now clients who are struggling with, digital lending, and their information has been hacked, as maybe Usawa was hacked a few, months ago, and people's data were dumped online. How are we meeting those justice needs that are now evolving? And the woman now, and somebody complained online and said, there are organizations that are working on women or children, and they're looking at indigent, the ones that are poor and vulnerable. But you'd find somebody who is in the middle of Nyakach in my village, is there with internet, and they're betting, and somebody maybe hacks them. There's identity theft and issues like that. So those are the things they're complaining about. They're not fighting about land anymore. They're not fighting about maybe the husband has left them. I think the client has evolved, and we must look at the youth especially, because that's the bulk of the African population. How do we meet the justice needs of the youth that are simply coming up? Finally, to wrap up the policy question, I think that we need to, be aware and participate in the conversations that are now happening around the digital economy, digital tax that are affecting access to internet, conversations that are, coming on privacy, because that privacy would affect court processes, and how we are getting these things, done within the court. So that's what the lawyers are trying to do, and looking at alternative policy in this sense. Huduma Bill, for example, looked like then that it didn't concern all of us. But your digital identity would affect the services that you're coming to get, because government was proposing then that you wouldn't offer services without somebody having an Huduma number. So what happens if I come in, I have a case, and I don't have an Huduma number? Maybe I'm Nubian, we are stateless people. How are you going to handle and deal with these particular people? So I think lawyers, especially people, and everyone within the justice sector, needs not to look at, digital policy as something that is far removed from them, but that's something that affects each and everything that we do, on our day-to-day. Back to you.
Yes. Linda, before we go on, I think we need keywords, explanation, or some things you're saying, and I was getting lost. Maybe you can update us. There are some words you are saying, you can clarify on the same issues, like there's a word you kept on using, vendor lock-in. What is that? We're operating in silos and legal informatics. Just if you can explain it to us and for the people watching who are not very tech-savvy. And then as you explain that, when we are coming to artificial intelligence, and where you indicated that we need to remove the human element. As we know, as a legal profession, our profession actually, it's a very social profession and an interactive profession. So what happens majorly, I think both for the judges, both for the bench and the bar, before, there was that issue about demeanor and body language. You see, such issues. So what happens when all I have to do is just read some words? Or we talk. So is this the end of the human interaction? We never have to leave or go anywhere. So with that in mind, and as you go on with that, also I would like also an explanation by the Office of the ODPP and the DR. Is Uadilifu accessible everywhere? If I go to Loyangalani, can I be able also to file my case to the people in the village, especially in ASAL area, that is the arid and semi-arid lands? Are they able to access all these facilities that we've been talking about today? Linda first.
Okay. I think first on vendor lock-in, what happens to, sorry, I like to give examples of relationships because we are very relational. So you are, 16-year-old, you're dating another boy who's 16, age of majority. You're 21 years old, you're dating somebody who's 21 years old as well. And then they leave you. So maybe you date, you get married, you have their name. And so you come in and you're called Linda X, right? And then they leave you. You have to come back to government and tell them, please change my name. Please do this to me so that I am able to move on to the next either relationship or whatever it is. So what happens with technology is that some technologies do not want you to leave their platform. For example, if you have a Gmail account, and then maybe you want to go to Proton Mail, which now is considered a little bit safer, So Gmail, under like European Union data regulations, it gives you the power to ask for your data. Even Facebook, you tell Facebook, I am leaving Facebook. I want to leave, give me my data. Facebook will give you your data on some machine readable format, and that data, you can move with it to its competitor. without any sort of problems. So any supplier that gives you something and uses vendor lock-in just means within the contract sometimes, and then also within the hardware and framing, so that you can't go anywhere else other than them. So they remain with your data, they remain with everything. You simply walk away as that person who's just been dumped, and you have nothing with you. So we're trying to prevent that and say for judiciary, for example, the questions we need to ask is who is supplying this data. If there's this collaboration between the judiciary and Ministry of ICT, for example, you have interns that are coming in from the Ministry of ICT that are supporting, judiciary. Exactly, is it Google that is running this thing? Is it Microsoft? What's the role of Liquid Telecom? I think those are the questions that we should ask as lawyers in that particular sense, and ensure that there's no vendor locking in that sense. The day we want to up and leave, we're happy to up and leave, and our data still belongs to us. The other thing that we is tied to this is also on, like, data flows. Data comes from one country now and goes to another. So for example, the companies we are dealing with are not Kenyan companies, most of the ones that are providing our infrastructure. And so they have their own data rules. If it's a Chinese company, for example, Huawei, they have their own data rules and how government accesses that particular data. Are we asking questions on how that has an impact on the data that we are collecting through our court processes, for example? So that's on the vendor locking. 2, on the, I think, artificial intelligence and legal informatics. Legal informatics is just using data within the legal sector to ensure that it informs decision-making processes. It can be used for predictive analysis. And I'll give you an example. In the West especially, now you have people studying judgments. Like, you come up with a formula, it studies a particular judge. And you realize that this judge, they give you a favorable ruling when you mention maybe the word indigent, poor. So the algorithm will score this judge and tell you, when you're writing your judgment, when you're writing your submissions, use these words this many times. And then, because they are easily convinced with that particular word, some people have said that is bad use of technology, because now you're getting into behavior analysis where you can actually predict someone's behavior, a judge's behavior, and play with it, So what we're advocating for is just ethical use of data, in which you can have the data we collect from our courts, because every day there's data. We are digitizing processes, which is somewhere we need to begin from. But it needs to ensure that there is efficiency in the end. We need to see if, for example, Kisii has many cases in a particular way, or Kisumu has cases, and you know that these are the type of cases in Kisumu. You know how to allocate even judicial staff, in that particular, area, without just throwing in people everywhere and transferring them everywhere, without taking regard to the data that we produce. Finally, on the human element, on how we thrive on body language and things like that, I think the legal profession is changing, and it's no longer not too much about body language. So there was, I think, a case in the US where they wanted to see, when COVID began, they were asking that lawyers actually show their entire body and witnesses and just note your face, because there might be someone in the room who is coaching you, giving instructions, or that particular sense. And so it was an argument that sort of is never ending, just because the judge needs to see the body language of the client, of the witness, and what they're saying and how they're feeling and their body language. I think that we are slowly being replaced. The things that we used to traditionally do are slowly being replaced by technology. And what we must do is to work together with technology. Just not look at technology as something that's coming to replace you, but something that is going to improve efficiency in that particular sense. I see people still taking notes, or judiciary looking for, vendors that are going to still transcribe notes. But you have, technologies like Otter.ai, where you simply speak and it transcribes, and the moment you're done, it is near perfect. It still listens to the African accent and knows it, So I think that we must figure out how to balance both the technology and the human element. The people that we are looking at, for example, my kids attend school on Zoom. They have changed. In just a few months, they have changed. We used to think, we need to find someone for them who will help them log in into Zoom. They log into Zoom themselves. They know when somebody's passing, when you're passing behind them, they know how to put off their video. They were doing exams, and my daughter kept, giving me signals. She'll put off a video quickly and ask me, "Mom, what's the spelling of torch? Torch, torch, torch. What's the spelling?" And be like, no, you're not cheating in exams, and I'm here. So those are the kind of clients you're going to be representing in another 10 years because they've mastered how technology works. I showed them Microsoft 365 on how you can actually transcribe your notes. And now they don't want to type. They're like, why should we learn how to type? Because Microsoft 365, you simply put the dictate button and it puts the spaces, the full stops, everything you have said, So I think we need to look at it in that sense and say, our client that is coming that is now in high school, it's that client that has a phone that teachers are trying to smash, They are going to change. They're the ones who will be there. And startups are now pretty young. If you look yesterday in the news, there's a Nigerian startup that raised 200 million from Silicon Valley. And those people are barely 30, The young people are going to raise money. Those are the people who will be your clients in that particular sense. How do you tell them that you can't use technology? And they're the ones who are building technology. I think we must quickly change, shift our mindsets, and also, go out of our way to look at how to learn. Where are we learning? What are the learning platforms? If the Lawyers Hub is conducting trainings, and this is me plugging in, look for such trainings and look at, can I join in? Can I learn quickly as a lawyer? That will change even the number of clients and the quality of clients that you're attracting, because the money we have and now is running, it's being run with the big 5 tech companies, Amazon, Google, Apple. Those are the ones that have the money and the startups that are aligned to them. Are we ready for such particular clients in our economy? I hope I answered your question.
Thank you very much. On the issue of whether uadilifu is accessible to the common mwananchi, I actually said that the office is in the process of developing an interface where, a secure one at that, where the public can be able to, on a click of a button, to be able to access what is in the system. But however, what has been filed in court, and I think this is something which my colleague from the registrar will be able to confirm. What has been filed in court, for instance, if it's a charge sheet, at the end of the day, it will go to the other side, it will be uploaded, it will be downloaded and printed. So they'll still have a physical file. So if that's the kind of access, then the public can be able to access that particular document. But on the platform, I think the person who can be able to access immediately is the person representing the accused person in the case where we are dealing with an accused person, or if the client has access through the advocate using the portal which is used, then they can be able to get it. So right now we are 80% where we are able to process that, a tool where they can be able to access whatever document we have uploaded in the system. So that is work in progress, and you have to remember that this is something which we have started rolling out. We have only rolled it out in Nairobi. So before we can be able to roll it out throughout the whole country, we also have to test it and see how secure is it, for our clients who happen to also be the members of public and also the accused person included. Thank you.
Yeah, thank you. That was my query, whether it had been rolled out in the 47 counties, but I think it's only in Nairobi.
Yes, it's only in Nairobi, strictly in the court stations in Nairobi, which should be, that is Milimani, Kibera, Makadara, JKIA, yes, and the City Court. Okay. That's where we are at. And of course the High Court, murder cases. When we are dealing with issues of judicial application, petitions, those, and the criminal appeals. That is where we have started rolling out the uadilifu case management.
How soon should we expect it in Loyangalani?
I can say that now that we are comfortable, most of the council within the Nairobi region, Nairobi County, are aware of, or they have been taught. You have to also take into account that the regional coordinators of the 9 regional coordinators have also been trained on how to use the uadilifu system. So now we are ready. So we'll start possibly with the coastal region, move on to the other regions slowly. So this is work in progress. So I would imagine by the end of the year, the 47 counties should have known how to deal with the Wadilifu system.
Okay,
Yes.
thank you. The same for the case management system. Is it rolled out all over the 47 counties?
The e-filing system, is currently in Nairobi, only Nairobi, but you can file a case from wherever you are outside Nairobi if you have a case within, the Nairobi courts. So it doesn't mean that you have to be in Nairobi. But if you are a lawyer, for instance, or you are a litigant, wherever you are outside Nairobi, you can still access the e-filing system. So let me clarify. Yes, you can access the e-filing system as an individual. You don't have to be represented by a lawyer. You can access the e-filing system as an organization. You don't have to be represented by a lawyer, but you can also be represented by a lawyer, and you can access the system using the law firm's name. And once you are in the system as an individual, you can initiate a case. You don't have to have legal representation. You can file an additional document on any other existing case that had been there before 1st of July. You can also check the progress of your case if you are an individual. You don't have to be represented by a lawyer. You can do that as an organization, and of course you can do that as a law firm. So I just wanted to clarify. I think the question that I was answering when I said that you might have to go through the lawyer is when you have a lawyer, you have legal representation, but still you want to be linked to that case for you to follow the progress without necessarily going through, your lawyer. Because if you have to go through your lawyer, you have to ask the lawyer for the account details. But you can have an account, you can request that that case be linked to you, and you can then view the progress. So yes, it is accessible to everybody.
I think a clarification that I would require is that if it's accessible to everybody who has a case in Nairobi.
Yes, if you have to file a case within the Nairobi courts.
Okay.
So for instance, you want to file a case in Kericho courts, for instance. The e-filing system has not been rolled out to Kericho. So the system is not in Kericho law courts. The system is only within the courts in Nairobi.
So how soon should we expect it in Mashinani?
Okay, during the launch, as I said, we are 3 months into the journey, and as of 30th of September, I can tell you there were as many as 2,449 accounts that had been opened. And what we needed to do is to ensure that our servers have been upgraded so that the traffic and the data processing can be more efficient. So the Chief Justice is about to roll it out to Mombasa within maybe early next month, and then thereafter to Kisumu, the way he had said in his speech when he was launching the e-filing system. So within the year, we expect that it will be rolled out to Mombasa, Kisumu, and thereafter Nakuru, and then we can now have it rolled out to the entire country.
Okay, thank you. Now, Linda, if I may come back to you, as you've seen, and that's my concern, technology is evolving, as you say, even in Kenya and in Africa, but it seems as if it's evolving more in Nairobi. As you said, we have 47 counties, and that's the concern I have. Are we reaching out to the people in Lodwar, in Marsabit? Are they this up to par? Maybe we are moving fast, but my concern is we may be living quite a large population. So what happens to the children in such areas, or children of pastoralists? Do they have this access to education? What happens to them?
It's at the divide, what now they call the digital divide, where you have, even for online learning, there are people in Nairobi who have never been disrupted by COVID. Schools went on as usual, and they will join their next class as scheduled. But you have, children, across Kenya who cannot access internet, do not have a device, because now if somebody tells you join an online class, it means you must have something to access. The numbers, I think, by GSMA, comparing to GSMA is an organization that works, it's a mobile association of mobile organizations, comparing to the data by Communications Authority, we all say that we have mobile penetration, but that mobile just means that somebody has a phone. Mostly it's a basic phone. Not everyone can afford a smartphone. Once they have that smartphone, not everyone can afford data because data is expensive. If, and this is what, if you look at young people who are making calls at night, because data now is cheap at night, companies have, offers that they give, in the night in that particular sense. But why do we have to get to that? There's an argument that like internet should just be, it should just be free. Like, but when we started taxing water, you knew that nobody was going to give you free internet, and I think it should not happen. We need to have free internet because this is what can happen for a country that has free internet and a country that can remove tax on laptops and phones. If you're in your village, people are coming to Nairobi to be house helps, or going to Saudi Arabia to go and be house helps. Imagine if your local member of parliament just focused on, I am going to teach these people at my home how to code. Let them learn how to code. That customer care service that we're talking about, we can change it and say, actually don't have to be a clerk within the judiciary. You can outsource this, customer care services and say, you have a laptop. Please, we will set you up. You will answer calls on behalf of the judiciary from your village in wherever, That's how India has figured out customer care in the US, because US organizations are subcontracting Indian companies to do customer care. So you'll call and expect an accent, and somebody will be like, thank you for calling, how are you doing? And you're like, no, I expected to hear an American accent. So I think the more we engage on, human rights issues, which are now digital rights issues on access, especially as lawyers, we'll get to some point of, being relevant for society in that particular sense. I think the discussion on digital tax and, and how to tax, infrastructure, counties are, I think my view on counties is that counties are, it's self-defeating, that counties would tax so much to get telecommunication companies within counties. Because if you're crossing internet from Nairobi to Kiambu, you're going to be charged taxation by the specific county. So now telecom companies are thinking, why would we go to Nyandarua? It does not help us to put an extra mast, a booster, to boost your connectivity, because that county is going to tax you more, and it's not Nyandarua County only. Many counties are actually doing that. So I think counties need to look at it in the sense of, if we want to be closely linked to development, we must have these incentives that would, help telecom companies come in and set up. Taxation and licensing that they're charging so much for should be removed so that people actually have access. If you're setting up, for example, you're a non-profit and saying, we're setting up a whole building that has free Wi-Fi, please come and access internet, come and study, things like that. You should not be punished by your county. And they come in and say, do you have this license? Have you paid this much? All those costs are prohibitive for us to develop. Finally, I think that what we could do best for the next sort of generation is look at how do we involve ourselves more into revenue allocation. And this revenue allocation has now changed. It's basically on digital revenue allocation. Can we give specific, even organizations, for example, we have countrywide innovation hubs. So countrywide innovation hubs is an association that's based across the country, and they have innovation hubs that are trying to teach young people to code, give them access to internet, and also connecting them to other countries as well, so that they supply, software. If you heard about Andela was an organization that was teaching people to code. They teach you, and then they also connect you with US companies that were looking for young people who could program software. Andela has closed down this year because they're only doing well in Rwanda. Rwanda was open to them and saying the government will give you, land, build what you want to build. The government is going to give you access to this and this. If we look at that particular access, we'll leapfrog our country and our counties especially to the next sort of level. Money is not in Nairobi. The money we should be fighting for is that money in Silicon Valley, that money in China that people are looking to for business process outsourcing. That's what I think we need to look at, moving forward. Okay. On the ease of doing business, there's discussion now on the startup bill, which was supposed to improve, the startup bill is supposed to improve startups, because startups are very, young companies that are disrupting how business is done. If you remember Uber, for example, how Uber came into the market and said, you don't have to call somebody to come to be your cab driver or wave and get a cab. They simply just said you could use an app and then call your Uber. So I remember a few years ago, I told my mom, I think it was in 2012, when Uber now had launched. They launched in 2008 from the economic crisis, and then they came into Kenya 2012, 2013. And so I'm not going to say maybe my age, but so at that particular point I asked my mother, please could you give me money so I could begin an Uber? I spent like 2 days convincing her on how Uber worked, what it was, and she's like, is there anybody in this country who's done an Uber business? So she told me to go and get a job with the judiciary, that I needed to be serious. So anyway, we let it park. But the first people who did the Uber business made so much money. They bought like 4 or 5 cars, and then before everyone noticed, everybody came on board. The same thing about people who sold quail eggs. The first people who came on board sold quail eggs, we all believed them, and then the market was flooded. Now I see quail eggs at Carrefour and nobody wants them, So that's how I think, business should be, that we give young entrepreneurs, and in any profession, even within the law, ecosystem, that we give them the opportunity to try out an idea. Our business structure as it is now, there's no for trying, allow me to say like that, there's no for trying. You have to do, and you have to do it well. So if I want to run a business, if I want a physical location, I must go on eCitizen, register my company, And the moment I get out of eCitizen, the system has automatically given me a PIN number, NSSF, NHIF. Like, it's like somebody just winked at you and already you want them to get married. Like, it was just a wink. I think we need to stop that and not, give obligations that when somebody's just trying to do business, especially a young business. Tunisia and Senegal have simplified this process and said that when you're setting up a new business, you can try out. You don't need all this particular licensing that we have, in this particular country. So we've been engaged at the Lawyers Hub with the startup bill. The startup bill was published by Senator Sakaja, and we have taken the position that it actually does not solve the questions on ease of doing business. It encourages double registration. It also brings in the issues on taxation that are actually not helping. And the fundamental question is that, does Senate have the authority to discuss money issues, So I was on Citizen on Monday and differed great sharply with Senator Sakaja and said that we need to look at the problems and not just look at, the political angle, that this is good for young people to tell them, we are creating employment, we are making ease of doing business, but are we actually fixing this particular issue? So I think I'd want to urge the lawyers to engage on the startup bill. I think it's important for us, even for our registration regimes ourselves as law firms, that do you have an opportunity to try out something? Are we changing how we, the dissolution of businesses, for example? It needs to be easy in the beginning, because the first 2 years, like they have said, African startups have a failure rate of 58%. Think of your friend who set up a business 3 years ago. Are they still in operation? Do they still have to go back to companies registry and say, please remove me, I don't want? Do they have to go back to the county? The county comes in and tells you, last year you didn't pay your licensing fee. You will still pay it. And that happened to me a few years ago. I don't think that needs to happen. People who haven't made money should not be forced into the, paying all these things and licensing fees that even for supplying juice, you still have to go to, KEBS and everyone else. And even for water, who taxes water? I think we need to be angry at such little things. Because if you let a business grow for the next 3 years, they're going to be your biggest taxpayer. Just give them time. They will figure out their business model. They will figure out who's their client, and then they will be ready to do. So I think the ease of doing business in Kenya is actually, there's no ease of doing business according to the World Bank, rankings that they do each and every year. We can do better, and I think lawyers need to engage in that particular conversation especially.
Thank you very much, Linda. That will be all from me.
Thank you. Linda, just as we wind up, because you really have hogged on time, but I'm not complaining. So what are the opportunities for lawyers who may be interested to be a part of the very interesting things that you do at the Lawyers Hub, and keeping in mind the emerging trends of practice in the legal space? Maybe you can just give a brief highlight or tell us where to go and check. so that we can see how we can also benefit from this. You said $200 million. I would like that kind of client in my office. So yes, tell me how to reach them. Thanks.
Yeah. I also wish I had such clients. We are trying, and I think betting on startups is a good thing, because in another 2-3 years, they're going to take over the market. This week, the UNODC launched a hackathon on blockchain and how we could solve corruption. And so I had the opportunity to be there, and Professor Bitange Ndemo, who was also on the panel with us, said something very interesting. He said that the next, Amazon is coming to supply your vegetables. Are you ready? And I was like, okay. I haven't thought about it like that. And he said, we need to, work together so that we don't perish as fools. So there's an opportunity for lawyers to engage in protecting their market, especially their digital market. Imagine the discussions around the Africa Free Trade Agreement. Are you involved in them? Do you know what is going to happen when, we open up these particular spaces? Ghana has been at the forefront and is now hosting the Secretariat. I think that's a great opportunity to engage in whatever you're doing, whether it's a professional organization, whether you're into markets, there's a place for you within the Africa Free Trade Agreement. Discussions are still ongoing. We have discussions now on the US-Kenya Free Trade Agreement. They have an impact on how trade is going to be done, on data flows, on how data is going to move to the US, on intellectual property, I think, and even on professional exchange. The UK, I was once denied a visa to the UK, and I wrote about it on, on social media, on Twitter, I ranted. And so there's a journalist who took that up. And during this year, as the president, actually this year, when the President Uhuru Kenyatta went to the UK there was the UK Africa trade event. And so they wrote a paper and presented it to that forum and said, there is no cooperation between the UK and Africa if Africans can't get visas, and the African professionals. And so there's an opportunity now, and we are discussing on how there could be professional exchanges between the UK and Kenya. That how do we, as professionals, get visas and work visas easily to the UK, because you're already acknowledged by your law society and bar association. Why wouldn't the bar association in England, for example, give you that particular guarantee in that particular sense? So I think there's also opportunity on migration and migration issues that are really, sort of pertinent. And now even digital migration, you can become a citizen of Estonia without ever visiting Estonia. Can we get clients who we convince that, by the way, najua watu Estonia, naweza kupatia citizenship, unajua ni aje, So can we look at such opportunities and start, helping in that particular case? We have people now in Canada and Australia who are really big on, can Africans come and work in these particular countries? Can we do trainings, get people, convince them they could move? We have clients who are really rich, they have land and stuff and they're building malls. Can you convince them that you don't have to build a mall, you can become a citizen of an EU country and I can process that for you, for example. So I think those are the opportunities I see in migration and trade. In the digital sphere, there's still opportunities in tech policy. We have digital rights that have not really been fought for. Freedom of expression online. If you look at Ethiopia and how they're limiting freedom of expression. If you know this blogger called Edgar, and he was arrested under the Data Protection Act, for exposing somebody's visa status online. How do you represent new clients like that? The Data Protection Act has not really been exploited as much by lawyers. We need to do data impact assessments within the act. So you need to get a client and tell them, by the way, we can do this data protection assessment. Are you up for it? So we sort of create problems and then create solutions for them within the digital sphere. I think that will be a great place to start. We also have elections coming up. In 2017, lawyers were not, ready for open the servers. They played us when they were saying, open the servers, no, people are asleep in Germany and France. It's not true. Servers run 24 hours a day. Now we are more prepared as lawyers to represent these people who are going to lose elections on digital platforms, from counties to senators. Are you reading and preparing for that particular aspect, So I think, the opportunities are endless. Please feel free to visit lawyershub.org. We have so much content on YouTube as well. We have content from the Africa Law Tech, festival that handle each and everything that you could, ever ask between the confluence between law and technology. And you can follow us on Twitter, Lawyers Hub Kenya. Yeah.
Thank you, Linda. Linda, please take over with our next speaker.
Our next speaker is Mr. Stanley Mwangi, the CEO of Global Sites Limited. Mr. Mwangi is the founding CEO of Global Sites Limited, a software development company specializing in legal software that enable legal practitioners to digitize and provide legal market solutions and software in contract management and e-filing. Stanley is a travel addict and can literally live in the airport. He's a geek techie who is passionate about new trends in technology, especially legal technology. He's also a family man. Karibu sana, Mr. Stanley Mwangi. Yes, now maybe you can tell us more in the space of digital legal technology.
Thank you so much for having me here. I totally do appreciate sitting back here and just listening to my fellow panelists and talking about the digital space and the changes and the challenges that we've been facing. I'm living in that space. We started doing about legal technology in the last 10 years. And like as Linda is saying, and most of my other panel colleagues are saying, you could talk to a lawyer and you're telling them about digitizing, and they look at you and think, what are you talking about? Why do I need a laptop? Why do I need an iPad? Why do I need to digitize my document and put it somewhere? And it used to be a big challenge by then. But when with time, I totally appreciate the way things have changed. The Office of the ODPP and the judiciary, they have coming in, and other companies like Global Sites, that we are doing things that in a different angle and space, and that's and technology now people are starting to embrace it. I'm more particularly even happy like the way even the Law Society, even last year's annual conference was about digitization. So it's a space now that we've started embracing, and I think it's time that people move to the next level about it. Talking about digitization, it's something that as lawyers and the legal department of corporate companies and associations need to embrace, because now, like for example now, when you have systems that can be able to come into place and you're able to work diligently in those systems, you don't only increase your efficiency, you even increase your productivity, even your profitability, because you're easily able to work in the systems that you have and you're able to do. To just even able to answer some of the questions that are running around here. For example, if you have a digital platform like, for example, Global Wakili, you're able to do what? The system itself, from the moment you register a client, for example, you do the document management for that client, you do the calendaring and BU updates for that client. Meaning what? That at one particular time, either you're using your mobile phone or you're using your tablet, you're able to easily access the information that you need for a client. So that in the opportunity where like a client calls you up, right? You do not have to have the physical file itself and you to be able to get the update of that particular file. You're easily able to get the digital information from that phone. And I'm really happy what the ODPP and the judiciary are doing now, because in the near future, this is what we've been trying to fight for the last few years, that now those platforms that we're building for digitization of client data, that we can be able to have, like Linda is saying, the APIs that are connected to the platforms that they're building, so that even the client, like now for example, the system we built, a client is able to have a back-end portal, is able to log in, find out what is going on with their cases. I mean, find out, so today my advocate went to the court. What happened? What's the status of my file? What's the status of my bill, my fee note, So those are the things that one is able to do and be able to come up and be able to easily understand the things that are going on the digital platform.
Perhaps you can take us through the futuristic legal departmental law firm.
Well, thank you so much for that. In the last few months, with the corona pandemic that has come in, for example, I'll talk about Global Sites Limited, where we've been working in collaboration with LSK in a campaign dubbed Wakili Digitika. This is a platform where we've been trying to give law firms and corporate legal departments a platform that they'll be able to work with and digitize their departments. And in this, what are we saying? That you can easily be able to manage your matters, can be able to manage your files, can be able to have contract management systems that if you're a bank or if you're a corporate entity and you have contracts that you need to manage for your clients, you're able to do that digitally. Basically about client conflict checkers and stuff like that. And then most importantly, have user logins. I mean, we've gotten to the point where when a lawyer goes to the law firm, to the court, and they want to represent a client, and there's a file or something that has been left out, this is something that needs to be gotten even using the laptop or using a phone or phone that you have. You can easily go to the phone, open the form and open the client's details, open the client's form, and be able to get the details that you need from that particular point. So you're able to get the different features of the system through a platform that we call Global Wakili. This is a platform that enables the lawyers, the client, and even now very soon when we talk about interconnectivity and integration of systems that the lawyers hub, the judiciary is making up, we're able to connect them, and you have one platform where everyone is able to work from.
Thank you for that. Once again, I will take you back to accessibility. Yes. Now, as I keep on saying, what is the accessibility take up, especially in Mashinani? I will not stop with this because I think we are moving forward because we have more people in Mashinani than in Nairobi.
Yes, sir.
So Nairobi is way ahead.
Yes.
What about the people in Mashinani, even the professionals in Mashinani? Are they keeping up, or we are just living in a bubble here?
Good. Thank you for that question. First of all, I'm really happy what the government is doing, trying to lay fiber cables, and even the telecom companies. That is one thing that they're really trying to help us with, because when you go to most of the regions down in the Mashinani areas, you're finding that now, at least even 3G, you have 3G access of internet connectivity in the regions. So what we're helping in the access, like you're asking, Linda, is that we're trying to make solutions that are easily accessible and they're not heavy. I mean, the carriers or whichever technology you're able to use, whether you're using a mobile phone or even the SSD connectivity, you're easily able to connect with those solutions, the telecom solutions that you're having to that. Now, once we say this, in the end of the day, it comes to, even if you empower the law firm at the Mashinani area of it, and the back end is a heavy solution. So that's why we find it a bit challenging that when we go and find things that the way Linda is saying here, taxation of internet and connectivity on that side. So some areas are still being left behind. I've been left behind in a way that if you go there and you have a solution based there, like most of the solutions now are cloud-based. Now you find that if you don't have proper internet connectivity and speed, then you're not able to access them. That's why you find most of the accessibilities being cut out and fall out of connection. Or even nowadays when you go and if there's a court session going on, someone, at the end of the day, the judge is asking, are you there? Are you still there? Because the breakdown of the connectivity. So what I would urge even the government and the Ministry of ICT is, if the policies that we're making in IT to make sure that those connectivity in the Mashinani area is done well or even cheaply. For example, can you imagine if every corner of Kenya had an internet connectivity or cheap internet or even zero cost internet connectivity, and then everyone has access to internet? It will bring so much digital connectivity to the platforms.
Okay. And also what I would like to ask is the integrity of the system.
Okay.
Or
System.
Yes, of any system, because I
The
think for any system, what is my information safe, even the information for my clients?
Yeah.
Is it safe? Is it accessible to third parties? Is there one day I as a wakili will go into the system and I can't access maybe my information? Yes,
Good question.
the risk.
Good question. The one thing, like I've said, as we started this journey of digitization 10 years ago, most people did not have or did not even like to hear about anything called technology, even an email. And that's why even up to today, you find that most people have still a Yahoo email, and it's a law firm or a department, legal department, or Yahoo or stuff like that. Because people ended up being very skeptical about the security features that would do that. In 2010, a law firm I was working with, we wanted to digitize. And the cheapest solution they could get was an international solution. And where for access, we could only be charged a minimum of $50 per user per month. Yeah. So now we found that, and this information is being saved out of the country. So we found, and I'm coming to answer your question in this way now, that you find most of this information and access is stored out of the country most of the time. How do we do that? So we come in and we try and enlighten most law firms about data policy, about security, access, even laptop use. I mean, even the way you use your laptops at your law firms, you have to have a policy. How does it move from one person to the next person? How do you change your password policies? I mean, in how long do you change those passwords? They ran a campaign in the recent future about hacking and stuff like that. What are the policies you put about your ICT infrastructure? Those are some of the things that we try to highlight for law firms. And basically, we entirely work for law firms and legal departments and show them and see how we can be able to do that. But when you come back to the access of systems now, the question that you're asking, we try, and it's important for any good software making company to develop solutions that are secure, that you must, even as a law firm, you must ensure that your system, first of all, has even if it's the, let me use the smallest little bit of an SSL for security features, even for your website. That's so that your website is not hacked. For any software that you are running from your firm, you have to have encryption for that, for the data, for that. If it's a third-party solution that is not your company's or any, whether it's Microsoft, Linux, or any company, please get the fine details of the paper, of the fine details and fine paperwork that are for data transfer, for data access, for any information that may need on how do you get, if the company closes up, how do you get back your information? So this is part of what we really try and train up on law firms and lawyers to be able to understand what they need on data policies and security.
Okay, that will be all from me, unless my co-moderator has any queries.
I don't have any queries, but mainly just to ask how best it would be to simplify my practice when interacting with my clients who are not really interested in coming to my office, but they want things to be done.
Okay, good.
Yeah, because I really just want to do things simply and efficiently.
Good question. So allow me to mention Global Wakili again, a solution that we have actually been running a campaign dubbed Global Wakili with LSK for some time now, and even this Corona time where we are offering a certain discount percent, we'll discuss that later. That now a solution like this, what we do is that we've built a back-to-end connectivity that, if need be, for the law firm to give access to the client. I'm saying this because the access is purely granted by the law firm. So you create a link, you create a solution that it gives, sorry, not a solution, but a link that is sent to your client. They get a one-time password that they create themselves, and you create that, and then they're able to access to their system. Once you're able to access to your system, they are able to only access what pertains to them. For example, their file status, their billing status, their calendar status. So they do not have access to everything, but only to what you allow access to them. So whatever the information you give is what you at the law firm have given them access to. So they are able to say, so when, if for example, you get instructions from a bank, for example, allow me to use a bank as an example. The bank has a portal access to the system where they can give instructions through that. So you don't have to miss emails, you don't even have to miss a call, you don't have to miss a text that was supposed to be sent to you and told that we are giving instructions. So the legal officer on the other end or the client on the other end is able to get to your solution and be able to give instruction and leave them there and give feedback to the same. And even on the time where a document was supposed to be addressed, they can be able also to be able to access through the system and be able to see. Now this way now, what are you doing? You're easily making it access, updating your client easily so that they don't have to necessarily come all the way to your office to be able to know. And in case they even called you, you don't have to have the physical file. Trying to get a clerk wherever they are, be able to call them up and get you the file, take another 5-10 minutes to be able to look for the file before again you're holding the client or the call. So they can be able to easily call, log in their name, log in their telephone number or something like that, and you're able to call up their file, and you're easily able to update them on the current status of their file.
So thank you, Stanley. So I'm saying we are well within time, so okay. Please allow me to bring on board our next speaker who's attending virtually, Miss Janet Otero. Wangari.
Good morning, guys. Good morning, Aluso.
Morning. Hi, Janet. How are you?
Fine, thank you. How is everybody?
Salama. Karibu. So let me just do a brief of your bio before we can proceed, yeah? And sorry we kept you waiting. I had to go to the little room.
It's okay. It's very much okay.
So Janet currently practices as a partner in the Telecommunications, Media and Technology Department of OK Law Advocates. She has an in-depth knowledge of telecommunication and technology sector with a vast experience in contract negotiations, regulatory due diligence, and general advisory for digital services and products. She has worked closely with financial services institutions, ICT companies, government institutions, and startups for the past 5 years. This has assisted her develop a good understanding of the policies and emerging practices governing institutions and how they are affected by digital disruption. She continuously advises on the legal implications arising from intellectual property, alternative financing, cybersecurity incidents to ensure preventive policies are put in place to mitigate cyber threats. She also advises on sound data management and governance practices in light of data protection legislation and regulations and the need for compliance. So, karibu sana, Janet.
Thank you.
I would like just to give you a brief of where your conversation should focus on so that we really don't have to go way overboard. So we are largely living in a social media generation and era. And we have a lot of Kenyans, both advocates and non-advocates, who are running businesses on social media, Instagram case in point. And I sometimes feel like these people are running businesses and they are very clueless on so many things. E.g., we have people who are selling makeup or they want to create makeup lines and they're coming up with the components of their products, nail polish and all that, but they do not understand the intellectual property issues that come into play with this kind of businesses. Then when I rope, just to rope in another aspect of the same business concept is the issue of a digital tax and the regulations 2020. What is the impact of this on these businesses that are running their trade on the social media platforms, and what are the penalties therein? Thank you.
Okay. So first and foremost, with the digital disruption in the past few years, it's been quite challenging in terms of what private institutions have been doing to kind of just leverage on it, what public institutions are doing, and what individual citizens are doing to just kind of ride on this digital disruption wave. And you get that it's not only the small person that is now using technology to further their business strategies, but it's also big organizations, multinationals who are also settling in various jurisdictions to kind of just further what they're doing in terms of their business strategies. So with all these concerns and all the platforms that are available for people to carry out their businesses and their services, there are definitely regulatory compliance questions that will come into place, because we have several regulators that govern certain things that they do, and most of these businesses are hybrids. They may fall within certain sectors that are governed or not mainly governed. And the ones that are not mainly governed tend to be the dangerous ones, because there are no sort of market controls or market standards for them to follow. So you're looking at things that affect such sort of businesses or services that range from consumer protection to things like terms and conditions that they offer their customers, which end up being contractual to an aspect. You're looking at things that like privacy policies that they have in place, because they do collect a lot of information and data from all these people they're engaging on their platforms. You're also looking at now what is going to be touted as the digital services tax that is going to be imposed on people who offer such digital services or provide platforms for people to offer digital services and goods. And the thing is, with this particular sort of tax regulation that's incoming, there's a bit of disconnect with what people understand on the ground and what the regulator, that is KRA, has in mind towards streamlining the income that is being collected from this particular avenue. So I'm not a tax expert. I will not comment so much on the procedure of it, but the salient provisions are that whoever is offering a services to a Kenyan resident, whether you are located or you have physical presence in Kenya or you do not, you're subject to a digital service tax that can be collected when you receive your consideration for when the services are offered, or when you receive a commission because you're offering the platform which people can use to engage in buying and selling. So when you look at this particular provision, then some things are also not clear in terms of multinationals that have no physical presence, so to speak, other than presence on their digital platforms. Does it mean that they need to probably move and set up, or does it mean that their physical presence translates into their market presence as well? And then also, does it mean that they will pay tax in Kenya and then also pay tax in their respective countries in terms of the income they generate from their services or from their services in Kenya? The other thing to also consider is that this particular tax is also, it's somehow set off against the income tax that a person or an individual is supposed to pay annually. We know that most of these small traders are not tax compliant because of the nature of their businesses, and it's very hard to trace them in terms of just trying to shake them down and see whether they've been filing their returns or even if they have KRA pins to begin with. You're also looking at a situation where they're supposed to be accountable in terms of declaring the transactional values that they collect from these platforms, because you're supposed to be taxed a percentage of the value that you get from providing these digital services. So it would be good to see how KRA, because what they've provided is just the substantive terms, it would be good to see what procedures they come up with to enable some of these people achieve compliance. The other thing to look at is when you're offering some of these services, some of them tend to be multinational brands or tend to be goods that are procured from another manufacturer or a provider. Again, some of them are sold either as a marketer, a franchised or an authorized marketer. Some of them are just sold because I have an Instagram page and I can sell and I don't think nobody will catch me. Again, you get to come across things like intellectual property rights, such as trademark infringement and all those passing off that may be levied on you, especially individuals who tend to sell what I'd consider knockoff or trying to pass off international brands on their pages. So those are the things that some of these platform users need to look at whenever they're engaging in selling or offering services on their platforms or coming up with the platforms that will offer this sort of services. I don't know if that has answered your question to begin with.
You have essentially, but I'm thinking, so because again, my focus is on Instagram because that's where I see a lot of these things happening. You find that the traders post their images and you know, so that you can see what I'm selling and all that. Then the next thing you see the same image posted in another business entity claiming that we are selling the same product. So how do these traders protect their, you know, their images and products? Like, for example, Vivo, Vivo dresses me, and then you get someone copying the designs on Vivo and goes and claims Aluso attires and starts selling them off as their own ideas and all that. How are those kind of things to be addressed by these people who innocently copy these things without understanding the implications of what the things they are doing? And Vivo is a brand name that has been around long enough. If we decide to go after these people, they will definitely take them down, yeah?
Again, access to justice and access to legal services is something that is should and ought to be a continuous process. It shouldn't be that somebody tries to access justice only when they are wronged or there's a claim against them. So it should also involve constant awareness, skill, and knowledge being passed on to people who may not necessarily have been in situations where they've come across intellectual property rights and all these things. And how do we do that as probably as law society, as not-for-profit organizations, as public practitioners, as probably the judiciary, and as probably organizations such as KIPI? How do we ensure that the public knows that what I'm doing and what I'm carrying out is infringing on another person's intellectual property rights? And this can only be done through awareness programs. Awareness programs can be through digital platforms, which normally work the best with the kind of generation of the market that we are seeing, people who use their phones to access everything using Google and whatnot. But it can also be done through physical interactions. But given times that we are living in, of course, digital platforms are what we are campaigning and promoting to be used as some of the platforms that can basically spread awareness and sort of educate these people on the intellectual property rights of what they're doing. So when it comes to intellectual property rights, again, do people know what sort of intellectual property can be protected? Under what regime? Are we talking about copyright and literary works under the Copyright Act? Are we talking about utility models? Or are we talking about logos and trademarks? So once they understand that these are the kind of intellectual property marks that exist and that can be protected, how do you go then to confirm whether it's protected or not protected? Again, this is not a service or knowledge that is aware to the layperson that you meet on Moy Avenue or any other street. This is something that once you interact with the legal service providers, is you become to know that you can actually conduct a search on a mark or a search on a literary work or something at Kekubo or at Kipi. So once they're able to, you're able to break it down to them that these are the kind of marks that exist or can be protected. This is how you carry out a search. And it's something that can be done by the use of just your mobile device phone or walking to the nearest office and carrying out a search. If it costs this particular amount or doesn't cost this particular amount, then it's something they can go for. If it's a subsidized service, I'm sure a lot of people will engage in the particular uptake in this service. If it's something that's not subsidized, a lot of people will shy away with it, because also the enforcement bodies we have in terms of just enforcing and enhancing intellectual property rights cannot be said to be very effective. And I think a lot of people know this, and that is why they tend to get away with sort of infringing on other people's intellectual property rights. Because if there's no knowledge and there's no awareness in terms of what is the minimum or what is the type of marks that can be protected, then you best believe that the cycle will continue in terms of infringing on these particular marks. And if the enforcement agents are not even trying to go on the ground and basically equip citizens with the knowledge or the know-how or how to go about protecting your own mark and all these things, then it will keep on being a vicious cycle, because it's a whole ecosystem. If one part of the ecosystem is not pulling its weight, then it becomes easy for the other part to thrive in that sort of mess or chaos. So again, probably this is a challenge to LSK and the relevant bodies to kind of just engage and sort of be at the forefront in terms of just educating the larger members of the public, online traders, on what intellectual property rights are all about and what kind of protections they can be afforded.
My query will be on website creation and development vis-a-vis the legal issues on the terms and conditions. Because our lawyers normally involved in the creation of most websites and the involvement of dispute resolution clauses. Perhaps you could expound more on that.
Websites, software licenses, mobile apps, all of these things are sort of technological services that most of us will engage developers or entities to do this or provide this sort of service for us. The thing you need to realize is with most of these things, there's an aspect of collaboration. And when it comes to collaboration, there's the aspect that you as the content creator will be giving this particular person to bring it to fruition or to bring it to life. So you'll get that most of these people, you either enter into a contract for the purposes of being given these particular services, or you sign up to certain platforms or to certain websites or to certain sort of digital platforms to be able to enjoy or to generate your own sort of content from these particular things. So where you're signing up to pre-existing platforms, to a pre-existing websites, to pre-existing sort of digital platforms and all those, there are usually terms and conditions that exist that you're supposed to read through and opt in. These terms and conditions are the ones that are supposed to act as your contract. In the same way, I will engage a website designer, give him the content, he'll put in the work in terms of the programming and the coding and everything and give me a working website. I will engage him via a contract. And in the contract, it will be very clear in terms of, these are my obligations to you, these are your obligations to me, this is the consideration passing. And after the website or the platform of the software is up and running, I'm also expected to do for a minimum period to kind of just guarantee the smooth running of the platform. Where you're signing into existing terms and conditions, you're supposed to read them as if you are negotiating a contract in a boardroom. So of course, they are usually, like Linda said, they are usually the supplier heavy. So it's more of take it or leave it. Again, as you're reading through most of these terms and conditions, especially on platforms that are provided by entities that are not based in Kenya, you will notice clauses such as the dispute resolution can be very harsh in terms of the jurisdiction or the law governing it will be probably UK or India or Dubai, depending on where this country is based. Some of the tax provisions can also be very hectic in terms of that if there's any tax that they may be required to pay in Kenya, they'll gross it up or they'll add it to the purchase price or the consideration you're paying. So as you're reading the terms and conditions, read it like you would read a contract and ask, what are my obligations, what are my rights, and what sort of remedies or reprieve do I have in the case of a dispute if they do collect my information, if they don't deliver on what we agreed on, if the final product is not what I signed up for, is it somewhere that I can go and take them? Do the courts of Kenya mainly accept these terms and conditions as a binding contract by the time I opted in to be able to just kind of safeguard what I'm claiming before the courts? When it comes to the private contracts that you do with the website developers and the software developers, again, just ensure that your rights in terms of intellectual property are protected. Who will own the intellectual property at the end of the development? Who will have access to the website? How will they maintain it for you during the period that it's running? In the data that is collected in this particular website or information, how will it be used to further your business strategy? Who will own it at the end of the day? And how will these particular developers help you to just kind of ensure that your whole sort of ecosystem or digital framework is protected from things like cybersecurity hacks, things like being copied or people kind of just duplicating it and reproducing it? Is it regulatory compliant in terms of if I'm in this sector or if I'm going to operate in this sector? Are there minimum requirements that the regulator will ask me to adhere to in terms of what I put in my terms and conditions?
All right, thank you, Janet. We had purposed to wind up this session at noon, and I'm seeing it's noon. So maybe just allow me to ask you one last question, and then we can take questions from plenary. Wangari, I'm sure we have some few members who sent questions on the chat, and then we'll have those addressed by all the panelists at a go, and have a small conversation from our sponsors, and then we can wind up this session and start our weekend. So Janet, I'm sure everyone here knows about this Jerusalem challenge. We had hoped to manage it here today in the morning, but things happened. So we changed at the last minute. So my question is, do these the original people that came up with that dance challenge, do they have any rights to it? And I'm seeing that it has spiraled into something worldwide now. Everyone is trying to be a part of this. They don't want to be left behind. And I'm just thinking, if I was one of those people that came up with that dance, I would just lift those videos and look for compensation from all these people. But I don't know
Yeah.
if my agenda is legitimate or it's just attempts at being relevant. Thanks.
Yeah. I mean, in the world we are living in, there's all these viral challenges that keep on coming up, and in a bid to stay relevant and to stay with it, a lot of users tend to sort of just replay and reuse this what would be generally protected material. Again, the question is, one of the things that's usually advised to people is if you credit the creator as having owning the copyright marks or the intellectual property behind what you're reproducing or you're reusing for your own enjoyment or for your own dissemination, then you've taken a step towards mitigating the sort of risk you'd be exposing yourself when it comes to infringement. Because you remember, when it comes to intellectual property infringement, one of the things that judicial bodies or tribunals will look at is your state of mind and your intention when it came to infringing on this. Were you looking at profiting? Did you profit from it? Were you being sort of malicious? Were you told to take it down, cease and desist, and you refused? And what were the circumstances under which you are reproducing it for your own enjoyment or dissemination? So when it comes to the Jerusalem challenge, you'll notice that most people are probably, or are in most cases, using it to just kind of highlight their businesses and put their businesses at the forefront in terms of what the service they provide, but also in terms of the CSR activities they do, but also just to highlight the fact that we are in this sort of pandemic unity sort of situation, and we are celebrating our Africanness. And you'll see that in most of the YouTube videos or in most of the TikTok challenges, that most of them are crediting the song to whoever has it registered. And they are even issuing captions in terms of, this is just our organization taking on this song and this challenge by this person to kind of just let you know more about what sort of services that we offer and that. So the owners of Jerusalem would definitely be entitled to ask the streaming services and all those people to kind of just put a stop where they feel that it's infringing on the intellectual property rights. But you see, they've not done it because it also gives them an advantage in terms of, once I watch the video, I definitely want to go back to their channel to kind of see what the original song was about. And once I probably keep on going back to their own channel to look at the original work, they are probably earning revenue from the number of times I visit their particular page. So it's a double-edged sword. Sometimes it works to their benefit because they are catapulted more into the limelight and they get more fame and notoriety. But sometimes they might feel like it's infringing on what we intended this original song to do for our fans.
All right, thank you, Janet. So I'm just gonna read up how many. One, actually there are two. So one goes to Honorable Tanui. It says, I hope the same also applies to the subordinate courts. We still have challenges getting the link in some courts lists do not have the link. Then there's Bernard, and Bernard says that this is a very rewarding conversation. We give credit to our panelists, so asanteni sana. And Dina Murungi says that this has been quite an educative session. And again, credit goes to our panelists for the informative session that we've had. So Honorable Tanu, kindly address the issue of the subordinate courts, and then from there we can take conversation from one of our sponsors who I'll call out. And I'm informed that before we leave, there's something small for closing the ceremony, so don't rush out for lunch before tumalize. Asante.
Thank you for that comment about the links to the various courts across the country. And I had mentioned that for us to access the courts that are going on now, the online courts and the virtual courts, we have made it a policy and a directive has been given to us, the entire judiciary, that the links should be permanent and that they should be in our course list, running in the course list, and they should actually be in our website. So if there are courts which are not following that guideline, I've just taken it from that comment, and then we need to make the Directorate of Public Affairs and Communication in the Judiciary take it up and ensure that all the court stations have their links to the various courts in our website. And as I said, they are permanent and we are running on a uniform platform, that is the Teams platform.
Okay, thank you. So Boniface Gore, is he here? Just, you can use that mic to say something small. Boniface Gore is the CEO of Digimat Solutions, who's one of our sponsors. You can, there's a banner. This one, yes, thanks.
Good afternoon, everyone. Good afternoon. Thank you very much. My name is Boniface Gore, as you've heard. I am the CEO and founder of Digimat Solutions. And today's topic is very relevant to what I practice and what I do, which is helping enterprises and businesses to go online. I like what Stanley Mwangi said regarding data protection and security. And I also like what Ms. Janet has just said about who do you pick to do your online work. And just like this profession, a legal profession, and we have seen so many times people being called out, being quacks. They pose as lawyers, but they're not lawyers. And so is our industry as well, which is our digital industry. Today you find everyone saying that they can help you go online, and they will give you a figure that is very friendly. Tell you for 10,000 shillings, I'll give you a website. You are excited, you give them 10,000 shillings, you give them your content, they go online, they get those open source frameworks, you put your logo, you take your 10,000 shillings and they go. This week we have our tent, our booth at the Milimani Law Courts, and we have had stories. We have had wakilis telling us, how can I access my website? I engaged this company, they did the website, but we can't update it. Digimat Solutions is here to partner with law firms that want to professionalize their services. I've had issues where I engaged wakilis, and I used to receive my documents from so-and-so and associates at yahoo.com, and that's what Stanley was talking to. I mean, in this time and age, you're using Yahoo as your main email address. No one will take you seriously, okay? And as you also say, these platforms, Instagram, Facebook, they belong to someone else. One day they will wake up and close down. What happens to your data? You have a page that has following, 5,000 following, and then something happens and Facebook closes. So how do you get your data? How do you get back your clientele? And that's why we have come up with an offer to help those legal firms that are struggling to go online by giving them free domain. And we will give you professional advice on how to protect your domain, protect your data, so that it is you who controls it. Our banner has been here for some time now. I don't know how many of you have interacted with it. We are at the Milimani Law Courts. So after this, if you have time, please feel free to get in touch with us. We partnered with LSK so that we can help the enterprises to behave professionally, okay? Other than being online, we also help you to have the looks, the optics, so that you look more professional. Sometimes you can see, please forgive me, you'll be able to see a letterhead of a legal firm, and you're wondering whether that is a letterhead that befits that firm, okay? It's all about looks, it's all about graphics, it's all about what the eye sees. If you go to a shelf to buy something, you'll highly likely pick what is more presentable than the other, because it is assumed that the more presentable you are, the more quality you are, okay? So Digimat Solutions is happy to have partnered with LSK, and we thank you so much for giving us this opportunity. And we are here, and we are going to help you. Please, let's interact, let's talk, and let's help you to go online. We are looking for partnership. We are not looking for making money and running away. We are looking for partnership. So if you're out there and you have an issue with your online presence, with your systems, and so on and so forth, our contacts are with your headquarters, LSK headquarters. You'll be able to get in touch. Thank you very much for this opportunity. Thank you once again.
I would like to give a word of thanks today. First to my co-moderator, Ms. Aluso Ingati, our speakers today, and our panelists who've given very insightful discourse. To the members present here today for making the time to join us, our sponsors, our stakeholders, asanteni sana, and also the people who are watching us online. If it was not for you, this would not be possible. So I think we've done so well in time today. We are late by 12 minutes. We'd intended to finish by 12, but I don't think we are doing so badly. So asanteni sana, to have a lovely Friday and weekend ahead.
Really changed. For a few years, trust me, before we go where we are, trust me, it's really changed for our There's even cake. Okay.
So this is where you say, I am so and so, you exchange business cards and all those things you do. As we wait for the cake to be cut, it's really just a thank you cake from the convener of the Public Interests and Litigation Committee, Ms. Faith Odhiambo, who has been largely the person behind this very successful week. After cake, we go upstairs to third floor for lunch. Alafu wale wa Milan, please drop in for the evening plan. Cheers.
One, two, one, two. Good afternoon, ladies and gentlemen. Our very own convener ICT and Caro and Dinda want to cut the cake. So we're asking for your kind attention for a minute as we celebrate this milestone for the Law Society and for us all. Thank you.
Still going forward.